Dinesha Walton. All right, so Miss, you need to be out of that bed and you're not dressed appropriately for Zoom. All right, you need to put on a jacket or something, Miss.
You want me to call her and tell her?
Yes.
I'll text her.
All right, thank you. And I just sent her a chat.
Okay.
So if you just step to the side and I'll call you right back.
I've got two others up there right now.
All right, thank you.
Thank you, Chair.
Jorge Luis Martinez,
That is mine.
where's he?
Oh, you don't mind? Oh, where is it? Yeah, I don't like going through people's stuff. Not sure. Like the main, like to the right. Okay.
And I'll put her in the waiting room and just let me know when she is dressed appropriately.
Okay. I'll give her a quick call when I finish here.
All right, so in this case, where are we?
He's been accepted to PTD. I have the contract right in front of me. He's gonna sign that today and it's gonna be submitted.
All right, Norm, I need a reset date for PTD on Jorge Luis Martinez. All right, so we're gonna have you back on September 15th. Are you employed?
No, ma'am. I'm currently looking for,
Sorry, what?
I'm currently looking for employment right now.
All right, everyone, please whisper. All right, so make sure that you follow through on your contract and everything.
Yes.
All right, thank you for dressing appropriately for court. Just have a seat and your attorney will bring you your reset form.
Absolutely. Thank
All
you.
right, thank you. All right. And is she dressed?
She just texted me and said she's ready.
Okay. All right. So today is the plea deadline date,
Yes,
and is this going to be an agreement or jury trial?
there's gonna be an agreement, ma'am.
All right, so if y'all will get the paperwork ready.
I have several courts to be in today. Could we do this on another day? I mean, I've got,
I mean, we're here, she's here.
Okay, and we can do it via, I believe she's in Chicago, if I'm not
Yes.
mistaken, at least Illinois.
All right,
That's
so,
fine. I can text you when the paperwork's ready.
okay.
all right, so I'm gonna put you in the waiting room and they'll get the paperwork sent to you. Ms. Ferguson will need your email and her email. All right, thank you. And thank you for changing clothing. I appreciate that. Timothy Ray Ibarra. Good morning. So on this case, where are we on discovery?
Actually, ma'am, he is pending a psych evaluation. He is supposed to have that on September 19th. He's meeting with the judge.
Ah, okay.
I mean, not the judge, the doctor.
All right, Ms. Ferguson. I need a date in October for this. October 20th, council, is that good for you?
That's fine.
All right, so we're gonna recall you back on October 20th.
Okay.
Once you sign the reset form, you'll be excused, and thank you for dressing appropriately for court. Just have a seat and they'll bring the reset form to you, okay?
Okay.
Thank you, Judge.
Thank you. All right, so where are we on this case?
Okay, so we are awaiting another video to confirm the identity of the persons who were involved. And I've spoken with Lauren, she's requested it from SAPD. And so hopefully within a month, we would know what we're doing.
All right, Megan, when do you think this video will be in on Jimenez?
Lauren,
Oh, I'm sorry, it was Lauren. Sorry, Lauren.
Yes, Judge.
Hi, when do you think the video will be in?
Probably within the next day or so, Judge. I previously got a download link from the detective in March, so I'm working on downloading that initial one to see if it's there, but if not, the detective is generally responsive.
All right, Ms. Ferguson, oh, you're excused, thank you. On this case, give me a 30-day reset and state you'll need to be prepared to tender an offer at that time. September 16th,
16. I'm in Karn
okay.
and I've got a mediation in the afternoon. What about the 18th? Guadalupe, about
Doesn't Guadalupe start with a G and Bear starts with a B? And so we should be above them?
you should.
Who do we need to call?
Okay, so where's the fifth? I'm in Comal.
All right, so
I'll get a date in like September.
here are your dates, and
Okay.
you choose one of these dates. We have September 8th, September 9th, September 11th or September 15th?
September 8th is perfect.
All right, Norma, if you'll put this down for September 8th. All right, thank you
Thank you. Your
for
Honor.
addressing appropriately for court. Just have a seat and your attorney will bring the reset form to you.
Yes, ma'am. Okay, I'll be right back. Thank you, Your Honor. Appreciate it.
Anthony Ray Flores.
Good morning, Judge.
Good morning.
I'm present. Mr. Flores, he's also present. Your Honor, this is our first setting, and he's just notified me that he wishes to hire an attorney.
All right, let's find out. Hi, my understanding is you're going to hire an attorney?
Yes, ma'am.
When?
ASAP, like as soon as I leave.
All right, Ms. Ferguson, I need a 3-week reset on Anthony Flores. At that time, you need to have an attorney here with you. Otherwise, this is going to be your attorney. You understand?
Sounds good.
All right, what date, Ms. Ferguson? Yes. All right, September 8th.
Okay,
Thank you for addressing appropriate for court. Just have a seat. Your attorney will bring you your reset.
Thank you.
thank you, Judge.
Thank you. Rafael Gonzalez Sanchez. So on this case, where are we on discovery?
Yes, Judge. So I'm still downloading. There's a lot of videos in this case. I'm still downloading those. I have spoken with the state. They have tendered an offer. It looks like it's good for 30 days. And there is a motion pending for a modification of bond conditions that I'd like to also set for as early as we can, ideally Monday of next week.
So what is the modification of the bond conditions about?
We're requesting, my client is currently on a tether, full house arrest. We're simply going to be asking for a modification to tracking only or fully removal.
Right, so what does he need it removed for? I mean, what's the reason?
So currently he's unable to work.
So then you want it
Full house.
partial for employment?
Yes, Judge.
Have you conferred with the state about that?
Yes, Judge. They don't oppose, they don't seem to oppose on the partial. But I understand that Your Honor needs a hearing. So I
We
was,
can, if y'all are ready, we'll have a hearing right now.
Yeah, states in agreement to partial GPS for employment only and with the restrictive time period of maybe 8 to 5, so he can do his employment.
All right, and so you filed the motion already?
yes, Judge.
Do you have a copy
I
with?
believe I have a copy of it here.
If not, I still have that. If you want to do it.
Yes, please. And it's on 2 cases. So these are the proposed blank orders, Judge.
All right, so this PF number, is that, which one? Which PF number is the indicted case, or is there 3 cases?
2 cases, it should be a burglary of a have and then a continuous family violence.
Those are, if you want to write it in, Your Honor, those all got combined into one indictment.
Oh, so it's, all right, so then it's just the 2025 CR 007805 for both?
Yes, Your Honor.
All right. All right, the court is calling 2025 CR 007805 State versus Rafael Gonzalez Sanchez. Could I have parties announced, please?
Rick Peña for the state of Texas.
Cesar Montalvo for the defendants.
All right, and are you Rafael Sanchez?
Yes, ma'am.
All right, counsel, you're here requesting a modification of bond conditions. Off the record, it was my understanding that there was an agreement
Yes, Your
from
Honor.
both parties, and what is that agreement?
That agreement is to have the defendant's conditions modified from full house arrest to partial GPS house arrest with the opportunity for him to go to work with a window of 8 to 5 only. Otherwise, after that, he has to be at home.
That is our understanding, Your Honor.
All right, and also you understand that you're not to have any contact with the complainant?
Yes, Your Honor.
If you have contact with the complainant, if you violate these GPS conditions, the court will receive a report of the violation. With GPS, if it's partial for employment, let me just tell you what that means, because sometimes people are confused about it. If you are going to work or getting off of work and you're driving and there's an HEB right on your route, or there's a fast food place right on your route and you're like, it's right on my route, let me stop here. That's a violation of your GPS conditions. The only thing you will be allowed to do on GPS is go to work and return home, nothing in between. Do you understand?
Yes, Your Honor, I want to add that my job is HVAC and we travel sometimes to different cities. I understand they can probably keep me in the city, but I do travel from place to place, restaurants, hospitals, and
All right, hear me clearly. If you stop at a place and you're not there for employment, it's going to be a violation of your GPS.
Okay.
You understand?
Yes, Your Honor.
And it would probably be in your best interest if you are going to a specific place and it's a restaurant or some other convenience store or whatever it may be, that you let GPS know that you're there for work. You understand?
Yes, Your Honor.
All right. So I'll follow your agreement if you'll fill that out, please.
Thank you, Judge.
We can go off the record. Now, Ms. Ferguson, can I have a 45-day reset, please? And if you all both sign that once you filled it out.
I will do, Judge. Thank
Thank
you
you.
so much.
All right, September 29th is going to be your plea deadline date. So on that date, you need to let the court know whether or not you've reached an agreement with the state. If you have not reached an agreement, then your next court date is going to be a jury trial date. Do you understand?
Yes, Your Honor.
All right, thank you for dressing appropriately for court. Just have a seat and your attorney will bring your reset form to you, okay?
Thank you, Your Honor.
Thank you.
Thank you, Judge.
You're welcome. DeAnthony Germonte Gordley.
Morning.
Good morning. How are you doing today?
Doing just fine, yourself?
Oh, I cannot complain. You know, any day you're currently alive and your health is okay, it's a beautiful day. All right, so on this case, where are we on Discovery Council? I understand it's been completed,
Yes, Your Honor.
and the at-large case?
That was supposed to be filed, but I just got told this morning it hadn't been filed yet. The judge had to sign it. So
What is the at-large case?
it's an ABI misdemeanor.
All right. Yes.
So that at-large case is a misdemeanor. I've been in communication with the misdemeanor prosecutor. It has been evaluated and has been sent to a misdemeanor judge to sign off on the probable cause affidavit. So that's what we are waiting on. It's from the same criminal transaction as the felony. And I have given them a global offer that would encompass both cases.
All right, so is this a situation where this can't be accomplished until the misdemeanor?
Yes, Judge, because that pursuant to the agreement, it's entering into something on the misdemeanor in exchange for getting something on the felonies.
All right, and which court is that?
So since it's an at-large case, it hasn't been assigned to a court yet, so it will be with whoever is the presiding misdemeanor judge.
All
But I
right, so,
did send the email because we worked it out last time and the person from my office said I sent it off and it should be signed, but I checked this morning and it has not.
all right, and I noticed that this case has been on docket since June, waiting, I guess, for somebody to sign something. All right, Ms. Ferguson.
Yes, sir.
This is going to be the final setting for this to be completed and it should be completed by then.
Yes, ma'am.
If it's not completed by then phone calls need to be made. Ms. Ferguson, a 30-day reset, and this is going to be your plea deadline date, and this is the final plea deadline date.
November 15th.
All right, September 15th. Thank you for dressing appropriately for court. Your attorney will bring the reset form to you. Once you sign that, you're excused.
Yes, ma'am. Thank you.
You're welcome.
Thank you.
Who's here on Andrew Thomas Reyes?
Morning, Your Honor.
Good morning. All right, so where are we on discovery?
Sorry, go ahead. We need to move the evidence, Judge, from co-defendants into this defendant's case. I also need to review to see if there was a search warrant executed or the state of how this case came to be. But I can do that today.
Okay,
He also has, Your Honor, what is currently an unfiled endangered child case.
and that co-defendant case, is that the B case?
I don't know if you recall those ones we handled 2 days ago with
Kelly and
it was Cornelius Cox and.
Kelly and Jacob are. Where?
Oh,
Yes.
Yes.
that case. All right, Norma, what date did I give Suzanne Kramer and Cornelius Cox?
There you go, Susan.
And that was
I
from
believe it was
yesterday.
next Tuesday.
Next Tuesday? I think you are correct. Rick, your mind is a steel trap.
Yeah.
I think you are.
I think Cornelius is sooner than that, correct?
No, I'm sorry. The 19th was Cornelius and Kramer's was the 26th.
All right, so y'all will be back on the 19th.
It just,
Once you sign the reset form, you're excused.
Thank you, Your Honor.
You're welcome. Oh, just have a seat and they'll give you the reset form. Thank you for dressing appropriately for court. Larry Garcia.
He's at TA right now.
All right, let me,
Yeah.
all right. Let me see if he's on a PR bond. All right, the court is calling 2025 CR 00778 State versus Larry R. Garcia. Could I have parties announced for the record for the state?
Megan Galloway for the state.
Robert Gaona for the defendant.
All right, this hearing was scheduled at 9 a.m. It is now 10:18 a.m. Deputy Laura, was an announcement made?
Yes, Your Honor, and I was keeping that out there.
All right, and the defendant has not appeared. Counsel, do you know where your client is?
No, Judge, I'm reading a report. My number's no good. So
All right, state, all right, thank you. State your request.
We're requesting a judge's warrant, Your Honor.
All right, the court will issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right, thank you. James Edward Sanchez. All right, so where are we on discovery?
Your Honor, we did just file a motion for protective order for the CPS records, which I believe Your Honor signed.
Yes.
And we are making those CPS records available to defense today. And that's the only thing outstanding that I have notice of.
Judge, I was disappointed on this on August 4th, so I haven't really delved into this case yet, so I'll need a little more time.
All right, Ms. Ferguson, if I could have a 30-day reset for discovery.
Okay.
All right. Thank you for dressing appropriate for court. Once you sign the reset form, you'll be excused.
Thank you, Judge.
Thank you.
Thank you, Judge.
All right, who is here on Johnny Guy Ramirez? Good morning. All right, the court is calling 2023 CR 6932 State versus Johnny Guy Ramirez. Can I have parties announced for the record for the state?
Megan Galloway for the state.
Anthony Cantrell from Mr. Ramirez.
Are you Mr. Ramirez?
yes, ma'am.
Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Johnny Guy Ramirez who was placed on deferred adjudication in 2023 CR 6932 for the offense of possession of a controlled substance, penalty group 1, 1 to 4 grams on October 23rd, 2023 for a period of 10 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 4. In Bexar County, Texas, the defendant, Johnny Guy Ramirez, did then and there fail to report to the supervision officer as directed for the months of January and February 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True, ma'am.
We waive and abandon the remainders, Your Honor.
No objections.
All right, did you understand by pleading true to violation of condition number 4, court could find it true, grant the motion, sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor. It is to revoke the defendant, adjudicate him guilty, and sentence him to 3 years in the prison.
That is correct, Your Honor.
Are you asking the court to follow that agreement?
Yes, ma'am.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Johnny Guy Ramirez, ma'am.
All right, why were you not successful?
Well, I lost my job, lost my wife, lost my kids. I just didn't have no way of getting around anymore.
All right, when you say you lost your wife, lost your job, lost your children, what, they left you?
Yes, ma'am. No, and she didn't leave me, I called her cheating. Yeah.
Right, so here's the thing. If somebody is being unfaithful to you, that shouldn't cause your life to fall apart, because at the end of the day, usually what I've discovered, that person may have known you for only 10 years of your life,
I-
and you're letting your life fall behind, because of that.
Yes, I did, and then just, I raised my babies my whole time, the whole time, and I just didn't keep it together no more, just losing her, my kids,
Mhm.
everything. Remember my daughter was having brain surgery, remember?
Mhm.
And she's going through it again. And the first one was successful, so not to go through it again, and it just killed me finding out that she was cheating and just everything goes. But
Sometimes people will wait for us while we work our way through things, and sometimes they will not. I mean, it's just the way it happens.
you know, I just killed me to lose my family.
All right, any objections to the court review and the court summary?
None at all.
All right. So let me just tell you what the court summary says, and this may be a reason why she decided that she was gonna remove her star from you. It says that you failed to attend parenting classes, that you were calling the UA hotline, but you failed to submit to UAs, which usually means somebody's still using. And you were discharged from outpatient treatment due to continued drug use. And so that's why. And it says probationer did not respond to phone calls, text messages, mail letters, and reporting instructions left by field officers. Sometimes people practice tough love, and then sometimes people say, I'm done. I can't deal with this anymore. You're not trying to help yourself, so I'm not going to be a part of this. So I'm going to follow your agreement because you're requesting me to follow your agreement. Are you waiving your right to appeal?
Yes.
All right, the court is going to grant the motion, revoke, find you guilty, sentence you to 3 years in the prison, give you credit for any time served. And I'll request the therapeutic community. It doesn't increase the time that you're in custody, but if you take advantage of it and they accept you, hopefully it can help you maintain your sobriety. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreements, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. When you're released from custody, if you can't find a sober support housing, transitional housing, or if you need to contact somebody to help you maintain your sobriety, if I'm still here, you come back here. I'll make sure that we find a place for you, okay?
Thank you, I would like that.
All right, good luck to you, okay?
Thank you, ma'am.
You're welcome.
Thank you, Judge.
Thank you. Trayvon Stevenson. All right, hello.
How you doing, Your Honor?
All right.
Judge, this is a compliance hearing.
Mhm.
The supplemental report was sent into the court notifying the court that Mr. Stevenson was locked out of his portable alcohol monitoring device. I spoke with Mr. Stevenson about his circumstances, and basically what it boils down to is he wasn't able to afford the device.
Mhm.
He has employment opportunities coming up.
Mhm.
And he's in for a little time to get back into compliance. What I would ask is that we give him 30 to 45 days to get back into compliance with the device with weekly UAs via the IVR hotline. I did speak with the state, and the state is aware of everything that Mr. Stevenson has reported, and they do not have any opposition with the plan going forward.
Okay. All right, so Mr. Stevenson, I understand that some things that are asked of you require funds. And sometimes you don't have the funds for it, but you have to have it. You understand? Legally, you do. So we'll then alternate him in. Ms. Ferguson, can I have a 45-day reset, please? Okay, so I'm going to alternate in your conditions to include You say weekly testing,
Yes, Judge.
via the UA hotline. And there's to be no driving. And we'll come back on September 29th to see where you are with regards to the device.
Yes.
All right, and you may want to call, I know there are certain organizations that will donate the money. So get into compliance with the device. All right, is there anything else you need?
No, ma'am. Judge, I wanted to know also, when my suspension was over.
I'm sorry, what?
When the suspension was over for me to actually go and get my license again.
Oh, that's for half the term. And you actually have a 2-year driver's license suspension, but you can always apply for an occupational license, but we have to have a hearing on that.
So, Judge, I was gonna go over those options with him,
Okay.
telling him what steps he needs to take to
Okay.
get that packet.
All right. All right, thank you. And thank you for dressing appropriately for court. Paul David Marceau. Hello,
Good morning.
good morning. So is an offer tender?
We do have an offer, Judge.
All right, how old are you, sir?
I'm 43.
All right, Norma, recall this in 2 weeks for a plea deadline date, please.
No.
All right, September 8th will be your plea deadline date. And I need an acknowledgement of discovery done.
Get with that.
All right, thank you.
Thanks, ma'am. Thank you.
Thank you. Thank you for dressing appropriately for court. Just have a seat. Your attorney will bring your reset form to you.
Thank you.
Thank you. Stephen Lewis Lamont. Good morning.
Your Honor.
All right, counsel, where are we?
Yes, Judge. Discovery seems to be intact at this point. However, I know Mr. Limon is wanting to see about qualification for felony veteran treatment court, Your Honor. He's been in talks with them. We got an ROI signed for them as of recently, and he has an appointment with Ms. Sedina Ruiz, August 22nd, Judge. So they can get a packet together to see about if he meets criteria for the program. And we're requesting a reset date so that those processes may unfold and may be able to staff the case and see if he can be into felony VTC, Judge.
All right, so if y'all can do an acknowledgement of discovery for me, and Ms. Ferguson, if I can have a 30-day reset on this in state, was an offer tendered?
I think offers contingent upon whether he is accepted into the program or not.
Okay, all right, Ms. Ferguson, a 30-day reset.
Correct. Would you possibly have Thursday, September 18th available, Judge? Great, minds think alike.
All right, September 18th.
Thank you, Your Honor. Upon doing the discovery, may be excused.
Yes.
Thank you, Your Honor.
Thank you.
Thank you. Thank you for dressing appropriately for court. Esteban Tiarina. Where are we on discovery?
On discovery, Your Honor, I think we're about there, but they were getting me the CPS records, which they say were uploaded this morning. I haven't been able to check to see if I can look at them, but I have no reason to believe they're not been uploaded. And then the other thing, I believe there was some notes from some interviews, but those were uploaded today. So I'd want some time to review those due to the sensitivity of the case.
All right.
And then we'd be ready for a.
All right, Ms. Ferguson, if I can have a 30-day reset, please. And did you tender an offer or no?
They have not.
All right, so we're gonna get this 30-day reset, and on this reset date, y'all need to be prepared to tender an offer.
Yes, Your Honor.
Oh, September 18th.
I believe it's also, Judge, we had previously filed a motion for partial GPS.
Mhm.
The court had wanted proof of, to present like a schedule. And so I have a schedule from.
Oh, if you'll confer with the state and see if they have any objections.
Yes,
If they don't, then we will put it on the record. Yes, discovery and for the state to, just have a seat, sir.
Yes, ma'am. You have a great day.
Oh, thank you.
Judge, I just spoke to, yeah, they had already agreed. We just needed to provide this for the court.
Oh, okay, let's go on the record then.
And they've seen that.
All right, do you have an order?
It would be, that's why I was saying if we've already filed the motion.
All right, they'll pull it and then we'll do
Yes,
it.
Judge.
Okay, just give me a second, we'll do this. Oh, no, just a second.
Oh, I'm sorry.
Apologies.
Oh, no. All right, the court is calling 2025 CR 005588 State versus Esteban Tiarina. Could I have parties announce?
Rick Payne for the state of Texas.
Attorney Bill Simmons for defense.
All right.
Esteban Tijerina.
All right, Mr. Tiarina. My understanding is that there's a request to alter and amend conditions of bond,
Yes, Your Honor.
and that is for the defendant to be allowed to work.
Yes, Your Honor.
And those work days are Mondays, Wednesdays, and Friday from 7 a.m. to 5 p.m. Is that correct?
That's correct.
Any objections?
Your Honor, I believe the state did object originally, but the court did grant the motion pending the providing of the work schedule. So at this point, no.
All right.
And Ashley.
All right, thank you.
Thank you.
Thank you. All right, just have a seat and they'll pull the order and I'll sign it.
Thank you, ma'am.
All right, thank you.
You have a great day.
You too. Hi. Jesse Orozco. Hi, if you can have him come up.
Yeah.
All right, did the state tender an offer?
Yes, and we've rejected, Your Honor, and we'd like a trial date.
All right, do you want a jury trial or a bench trial?
Oh, jury trial, yeah.
All right, Ms. Ferguson, state. When are you all available for a bench trial? This is possession less than a gram
Yes, Judge. Is it less than a gram? Yes, it's less than a gram. It does have enhanced.
with the habitual.
But we would not be opposed to, I'm sorry if I heard you correctly, or a bench trial. We want to post that.
Oh, no, he doesn't want a bench trial. He
Okay.
wants a jury trial.
It probably lasts a day, Judge. The jury selection, maybe 2 days.
And if you'll confer with Ms. Ferguson on a date,
Thanks, Judge.
Appreciate it, Judge. Thank you.
you're welcome.
Yeah.
Just have a seat and they'll give you the reset form. And if you all could do an acknowledgement of discovery on this, please. All right, who's here on Roland Ramirez? Roland George Ramirez? Who's the attorney? All right, thank you. All right, come forward, please. Counsel, where are you on discovery?
I believe we have it all.
Has an offer been tendered?
The offer has been tendered. Let me, I guess, check this, double check to make sure the discovery.
Hello, good morning.
There may be some files that were too large for me to actually download.
All right, sir, how old are you?
41.
All right, Ms. Ferguson, can I have a 3-week reset for a plea deadline date on Roland George Ramirez? All right, September 8th will be your plea deadline date. Thank you for dressing appropriately for court. Once you sign the reset form, you're excused. You're welcome. Just have a seat. Your attorney will bring the reset form to you. All right, who's here for Luis Coronado? Good morning.
Morning,
How are you doing today?
just getting old.
But hey, what is the alternative to getting old?
I'm getting my first social security check October, the beginning of October.
Oh, hey, well, you know what? You don't look it. So that's a good thing too.
Thank you. I had to let it go through my head. You said that possibly.
Yeah, no, you do not. And, Vashan will tell you, I'm always going to tell the truth. If it's something that's going to hurt somebody's feeling, I'll keep it to myself. Much like Thopper and Bambi, where his mom said, "What did I tell you?" And he's like, "If you can't say anything good, then don't say anything at all." So, yeah, but you look great for your age.
So Judge, Mr. Coronado, there was a supplemental report sent into the court, because Mr. Coronado is requesting early termination of his case. He's been on probation since August 24th of 2023. 4 years, he's been on for 2 years of the 4 so far. He has completed all of the major terms of his conditions, 12 negative UAs and so forth. I spoke with the state. The state is opposed to the early termination. And I think Mr. Coronado has some more information I just wanted to provide to him.
All right, what would you like to provide?
I put myself in a situation I shouldn't have. I should have just called the police, taken care of it. But it's taught me a lot. I was a superintendent for a custom home builder. And throughout the years of dust ups, arguments, and fights from trades, I didn't learn that. I'd use it for when my situation occurred. All that was just, I guess, bothering me. I needed it out and it ended up bad.
All right, so let me ask you, do you have any other fees that are due?
Judge, I'll take a look at that really quickly. There is no restitution. He has paid for his fees. Let me double check on that part. Mr. Buck is his attorney.
I have negative or $1,000 above what I needed to be.
Well, here's what I can tell you. If you're thinking about getting that $1,000 back, that's going to take an act of Congress.
No.
It's sort of when you owe a bill, people are always on you to pay it. And then if you pay over, you just say, oh, okay, I know I'm never getting that back. So what classes did you take?
I had no classes.
No. I mean, did you ever take any classes?
No, ma'am.
All right. I see that I'm not the one who placed you on probation. So.
Judge, it's up to date with all of his fees. Like he said, he has paid for a little under $1,000. We did a TAP evaluation. There was no recommendation from that TAP evaluation.
All right. So what are your plans for the future?
Get my Social Security, maybe do some fishing. I haven't visited my dad's grave site in more than 3 years since I can't leave. So that's the first thing I would love to do.
So where are you planning on fishing?
The coast.
And what do you catch on the coast? Do you clean them? Hey, catfish would be very upset with you. So here's the thing. I'm going to grant your application for early term, but it is not going to take effect until, let me see what date. It's going to take effect on August the 19th. So you'll be on probation till August 19th, because whenever persons are on probation and there are complainants, I like to give everybody a chance to let the complainant know so there won't be any issues. You understand?
Yes, Judge.
All right, so you'll be on probation. He'll be on probation till August 19th. So if somebody can reach out to the complainant and let them know that he successfully completed probation. So the 19th will be your last day.
Thank you very much.
Unless you do something.
No.
You won't.
No. I'll do your office.
All right. So you are excused, and they'll give me the documentation to sign, and I'll sign it and date it as August 19th. Okay.
So my birthday will be a good birthday.
Oh, when's your
25th,
birthday?
the 25th.
Oh, wow.
So it'll be perfect.
I have
Yeah,
family
thank you.
members who are the 18th. So. All right. Who's here on Ashley Jones? All right. Thank you for addressing appropriately for court today. So today is the plea deadline date. Is this what is happening?
I've been in conference with Austin Stout, who's the prosecutor handling the case. He wasn't able to be here today, but we've conferred. We do not have an agreement.
All right, Ms. Ferguson. And he was here this
ma'am.
morning.
Yes, he was.
If you all will see about a jury trial date.
We will talk to her.
All right, you can have a seat. Your attorney will bring the reset form. Your plea deadline date has expired. The court will not consider any plea bargain agreements in this case without good cause. Otherwise, you have to plea open to the court. All right, thank you. Just have a seat.
Judge.
Who's here for Amanda Stephanie Ellis? All right, is she in custody?
No, Your Honor, I got in contact with her. She was under impression that her birthday was tomorrow. She's willing to come back tomorrow, Monday, whenever her friend allows her to come back, she will be back.
All right, State, do you have any objection to recalling Amanda Ellis for Monday? All right, she'll need to be here Monday. If she's not present, a warrant is going to be issued for her arrest, and she'll need to be here on time.
Understood.
All right, thank you. All right, Darlene Gonzalez.
Good morning. Frankie Sandoval on behalf of Ms. Gonzalez. Your Honor, I'm a little taken aback. I've had such good contact and communication with Ms. Gonzalez, yet she is not here this morning. We are trying to reach out to her. We have a very generous, wonderful offer from the state. I would like the opportunity to be able to convey to her, but without her presence, it's a little difficult on my part.
All right, State.
Yes, sir.
On this case, it is an unauthorized use of vehicle. He stated his client has always been present, but she's not here today. Do you all want a warrant or you want it recalled for Monday?
Have you had contact with her?
I've had real good contact with her. The only other criminal history she has, Your Honor, is a family violence case from a couple of years ago, and then I believe the DWI from about 2018.
I guess when you want to contact her. When you want to.
Yesterday,
Oh.
to inform her of today's setting. And I was in comfort this morning, Your Honor, and also to inform her I was going to be late, but that she needed to appear.
All right, do you want to try calling her? and
We
see-
have, Your Honor.
And no response?
No, Judge.
All right, state.
We're gonna be requesting a warrant at this time.
And I understand, Your Honor, we'll keep in contact. Thank you so much. Will the court be in session tomorrow?
Yes,
Okay. So
but, well, not tomorrow. Well, if she shows up tomorrow, she can show up tomorrow. The court is calling 2025 CR 0078001 State versus Darlene Gonzalez. Can I have parties announced?
Megan Galloway for the state.
Your Honor, good morning. Frankie Sandoval on behalf of Ms. Gonzalez.
All right, Deputy Laura, did you make an announcement in the hallway for Miss Gonzalez?
Yes, Your Honor, I did. She's been out there.
All right, defense, have you had contact with your client?
Yes, Your Honor, have had very good contact with client. And in fact, as of yesterday, was in communication, spoke with her yesterday.
All right, this hearing was called at 9 a.m. It is now 11:27 a.m. Your client has not made an appearance. State.
We're requesting a judge's warrant, Your Honor.
All right, so I'll issue a judge's warrant. I remand your client without bond. If she makes an appearance, then the court will reconsider.
I do appreciate that, Your Honor. Thank you so much.
All right, thank you. All right, who's here on Ariante Emmanuel Duran de la Cruz?
One Judge Shallot Sharp, family minister.
Is this a plea?
Yes, Your Honor.
Is it more than one case?
No, Judge. Well, it's one case with two different counts and two different.
All right,
They're
it's just
proceeding
that.
on count two of.
Morning, Judge.
Good morning. All right, let me do this. All right, the court is calling 2023 CR 7596 State versus Ariante Emmanuel Duran de la Cruz. Could I have parties announced?
Megan Galloway for the state.
Alex Sharp for the defense.
Could you have me move to the other? And are you Mr. De La Cruz?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. De La Cruz, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
File stamp for a plea, please. State, are you proceeding on the indictment as presented?
No, Your Honor, we are waiving count one and proceeding on count two.
No problem.
No objection.
Did you review the admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand, and count two, the state is proceeding on the offense of tampering with evidence with the intent to impair as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in, the right to remain silent. By entering in this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
All right, off the record for a moment. Deputies, could you bring out Mr. Polk? All right, we're back on the record. Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand that?
Yes, ma'am.
According to the plea, the state is proceeding on count 2. There's a $2,000 fine to be probated. The state recommends deferred adjudication, and there's to be restitution to Ethan Reyes. Did you understand that to be the plea?
Yes, ma'am.
Defense?
That's correct, yes.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 10 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with Ethan Reyes, and the cognitive thinking course. Did you understand those were recommendations from the state? And the court does not have to follow those recommendations.
Yes, ma'am.
To count 2, how do you plead?
Not consecutive. I forgot the word.
Guilty, not guilty, or no contest?
No contest, ma'am.
State, any evidence?
State offer states 1 in attachment.
No objections.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We can, Judge. The only issue would be whatever the restitution amount is. And so, like, when I conferred with the state, they didn't really have a figure on what the restitution is. We could go forward on sentencing in general, but if there is, whenever they come up with the restitution amount, if we could have a hearing on that before that is imposed by the court.
All right. So are you still employed at this location?
Yes, ma'am. I'm also in HVAC school as well.
All right, state. On this case, do you all have any objection? I'm assuming he's still a bouncer. I don't know if they trained them or not. From reading, it appears that
Oh, no, that's a contract. I do like HVAC and electrical. I'm no longer.
It does more construction.
Yes, ma'am.
now.
I'm no longer security.
No. My question is, according to this, he was a bouncer.
Yes, ma'am.
It appears that they would probably hire me as a bouncer if I just came in and said, hey, do you need employment? And they say, yeah, we need a bouncer. Okay, and send me out with no training. So my question is, state, do you have an objection to his continuing to be a bouncer at this club? I mean, at this place, what is it called? Private?
Yes, Judge. I mean, I would have an objection to that, but my understanding is that nightclub or whatever it is was closed down. So I'm not sure if he's still working for whatever.
He's not working as a security guard since this incident. He's doing.
Because while you're on probation, you're not allowed to have any weapons. You
Yes,
understand?
ma'am. Yes, ma'am.
And the name of this club was PRIVAT
Correct. Your
with no E. This is what happens when we stop spelling things correctly. And what time is this alleged to have occurred?
in the early morning hours.
Nothing good happens after midnight, and now really nothing good happens after 10.
Yes, ma'am.
Okay?
Yes.
Do you have any, thank you. Do you have any children?
No, ma'am.
So what do you do in your spare time?
So I currently work and I go to school. I'm in a trade school. So I do that.
What are you doing with your trade school?
HVAC now.
Okay. All right, court is going to sentence you to a $2,000 fine. That will be probated. Proof of employment within 30 days, no employment as a home health care provider with minors or as security. There's to be regular reporting by Zoom or in person, regular random UAs. There's to be no contact with Ethan Reyes. And I need a restitution hearing in 30 days. What date?
You said that's 2 things at 30 days.
30 days.
I can do. I can do, September 8th.
All right, state, on September 18th, you'll need to have proof of restitution.
Yes, Your Honor.
There's to be 200 hours community service restitution. That'll be waived if you obtain your trade school certification.
Yes,
If you don't obtain that, then you need to give me 200 hours. There is to be the state, do you want the cognitive thinking course? It appears that it was just somebody being placed in the position as a bouncer and they didn't receive any training.
Yeah. Judge. Yeah, we're not requesting that, but just I would request that he not be employed as any type of bouncer or security guard because he's not commissioned.
All right, thank you. There's to be field visits 1 time per month for 5 months. And there's to be the anger management course. Probation, is there anything else? Thank you. All right, the state is asking for 10 years deferred adjudication. Defense.
Your Honor, and I told Mr. De La Cruz that if he wants to, we don't have any objection to whatever the length is.
Well, do you want 10 days outside the agreement is a request for 10 years deferred adjudication? Do you have any argument for or against the 10 years deferred adjudication, or do you want the court to order 10 years deferred adjudication?
I would argue that 5 years deferred adjudication is sufficient. I believe Mr. De La Cruz, once he gets through school, that he's gonna whiz through his deferred adjudication. He's gonna pay. He's gonna work. He's not using drugs, not drinking, and that he'll be done with it early, and will probably provide or submit a request for early termination. We'd ask for 5 years.
All right, the court will sentence you to 8 years deferred adjudication. Is there anything else you need from the court to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement? Yes. All right, do you need a transfer?
So no, not entirely. Because of this whole entire situation, I became homeless, so I'm just living out of my friend's house right now.
Okay.
That's his mother's address.
That's my mother's address.
Okay.
So I just wanted something that was actually legit, like on paper.
All right, if you ever need a transfer, just let the court know.
Yes, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Oh, yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you. Have a blessed one.
Oh, thank you. You too.
Thank you, Your Honor.
Welcome. Angel Montoya. Are you all ready to proceed?
Yes.
All right, where's Mr. Montoya? Hi. Court is calling 2022 CR 0054 State versus Angel Montoya. Can I have parties announced for the record for the state,
Rick Pena for the state of Texas.
for the defense?
Attorney Bill Simmons for defense.
And are you Angel Montoya?
Yes, ma'am.
Did you review the document entitled State's Motion to Enter Adjudication of Guilt and Revoke Community Supervision and State's Motion to Supplement Pending Motion to Enter Adjudication of Guilt and Revoke Community Supervision?
Yes, ma'am.
Are you the same Angel Montoya who's placed on deferred adjudication in 2022 CR 0054 for the offense of injury to a child bodily injury on February 13th, 2024 for a term of 6 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, off of state's supplemental pending motion, adjudication of guilt and revoke probation. Violation condition number 4. In Bear County, Texas, the defendant, Angel Montoya, did then and there fail to report to the supervision officer as directed for the months of April, May, and June 2025 in violation of condition number 4.
How do you plead to that? True or not true? I'm sorry?
True, sorry.
Additionally, on the state's original motion to enter adjudication of guilt, state will waive all of those violations.
Any objections?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor, and
Yes.
that is for the motion to be denied to allow the defendant to apply for felony drug court. Should she be accepted to that, then fine. Should she not be accepted to that, then alter and amend conditions of her current probation to add SATIF followed by SATIF aftercare.
All right. Why isn't she reporting?
Your Honor, is the court inclined to hear testimony? Because I have one witness as well.
Yes, I want to know why she's not reporting.
If I, and then we'll call her, Judge.
Sure.
Okay. If I could call Leslie Banderas.
Right. Hello, could you raise your right hand?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Leslie Banderas.
All right. Counsel, you may proceed.
Ms. Banderas, how long have you known Ms. Montoya?
All right.
All her life. And you're familiar with her legal situations that she's been involved with, correct?
Yes.
Okay. And you've got a unique knowledge of that based on some of the organizations that actually, community organizations, the numerous community organizations that you're involved with, correct?
Yes.
Like, what are some of those organizations?
I have an organization, it's called Homies and United Network.
Mhm.
How we deal with the formerly incarcerated and their families by, providing resources or guidance into the right direction. I also work with TOPS, and I also work with a national organization called All of Us for None.
Okay. And in terms of your working with TOPS, what kind of work do you do with them?
With TOPS, basically, we just get together and try to provide the resources that the individuals that we're working with needs. Therefore, if I can't provide it, then of course I guide them to like TOPS, they're one organization, they deal with housing and stuff like that. As far as we deal more with like teaching the formerly incarcerated and their families on their rights to vote. And then again, we do a lot of mentoring as far as like, against bullying for the kids and stuff like that.
And you work a lot within the community, correct?
Yes, we recently just did a formerly incarcerated march that came out on TV. We did it, I think, on May 31st, it was the last.
And the reason I'm asking this is that so that you have some understanding of Ms. Montoya's, what she's dealing with.
Yes,
And so, you had mentioned you deal with the formerly incarcerated.
yes,
When she had gotten out, she was on a parole, is that correct?
yes,
And, but she did, bottom line, you deal with a lot of people in these situations, correct?
yes,
Would you say that she was putting her best foot forward to try to be in compliance with her parole and the new probation that she had received?
yes, from what I saw, she was completing, going to classes, and correspondence with her probation and her parole officer. We were even getting visits. She was getting visits to homes. So she, as far as I know, they were good visits, as far as I'm going over there. I didn't really, like, she volunteers. I have her, whether it's passing out flyers or helping us organize events, things like that. I mean, just nothing. She wasn't like the party goer or anything like that as far as I saw.
And so, and when she was doing the outpatient treatment, she was going to all of those classes, correct? Because you were kind of.
Yes, I was giving her rights to.
Yes, giving her rights to them. And to believe she was only 2 classes away from completing an intensive outpatient.
Yeah, I know one of them she did complete. I'm not sure if she was still needed to complete more.
And in terms of the parenting classes. She actually completed those.
Oh, yes.
Okay. And when you were talking, and the other thing, just when you were talking about the financial resources, again, it was tough for her. She got there, but there was some where she was making an attempt to do everything that she could. Would you agree with that?
Yes.
Okay. I'll pass it with you.
Any questions?
Just a few questions. I'm sorry, I didn't catch your name.
Leslie Banderas.
Ms. Bandas?
Banderas.
Valderas. And how long did you say you've known Miss Montoya?
I've known her all her life.
All her life. So since you were children, you guys grew up together, I guess?
I'm her mother.
Oh, you're her mother. I'm sorry. I didn't hear that part too. All right. So you being her mother, are you aware of the issues she's been having with substance abuse?
Yes, I've been aware as far as what she was, I guess, smoking.
Okay, how, to your knowledge, how long has she been abusing drugs or smoking, as you say?
I'm not even gonna lie to you, when my kids didn't even start messing up their life after they moved out of the house, after the age of 18.
Okay, so
She's always had I've never had problems with her in school, anything like that. She graduated, even had a scholarship to go to college.
Mhm.
She was good, so.
all right, so after adulthood is when these issues started to come about. And what did you do to try and help her with those issues?
Well, like I said, when she moved out is basically when she started doing all that stuff, the thing what I did was like pull her away. You know, like I said, she volunteers a lot. I have my own organization.
Okay.
So come on, let's go do this, let's go do that. And again, because she has kids, so my grandkids, I want them to see, you know, this is a positive way to go. Like I even offer counseling.
Okay.
Because we also offer that for free as well.
Okay. Have you yourself specifically seen her smoking marijuana or any other type of drug?
No,
Has she ever appeared under the influence to you?
no, I just want to clarify, like with this, what she's dealing with right now, I haven't. Okay, like when she moved out of the house, back when before she even got in trouble, there's been occasions that I've seen to where, yeah, you know,
Okay,
they
so
were doing that, but.
so in the past you have seen her smoke marijuana, but recently you're saying you haven't. Is that
Yeah,
what you're saying?
recently don't have,
Okay, so when was the last time you saw her use marijuana?
before she went to prison,
Okay,
and this was
All right.
years ago.
okay. And since then, you're saying you've been trying to help her get that issue resolved, correct?
Yeah, like I said, I was the one giving her the rights
So
to the classes and picking her up from the classes. Okay, like what do you have to do? Like, do you need to come up, give the lady my number, the probation officers, parole officers, they all know my number, they all call me.
okay.
We always correspond. Like I said, they go to the house.
Did you also help her check in with probation when she's supposed to?
Her probation officer, like I said, would call me because they switched all the time.
Right, yes. They
So every time they would switch, they would call me. So I would be in correspondence with them. Like if they felt that, oh, you know what, Angel, then she needs to come and see me for this, whatever, they would call me if they couldn't get over it, because she had her own phone. I provided that.
Sorry to
Yes, when
interrupt.
you-
So, sorry to interrupt. You're recommending that she be continued?
Correct.
All right, so here's my question for her. Either she wants to be on probation or not. She's not going to be released today. She's going to safety. If she doesn't want to go to safety, then she's going to be revoked.
Oh, I believe the recommendation was SATIF, or no, safety.
It's sad, but based upon the stipulations that were entered into and what she did, obviously there are major drug issues, and this is more than just, I think, can be taken care of by SATIF, because let me just tell you the reason why I say that. She's looking at 10 years in the prison. So she has some choices to make. Either I use drugs, you know, and potentially could go to prison for 10 years, or either I don't. And she made the choice. I'm going to use. So that tells me that her thought processes are not where they should be, and that she's in the throes of her addiction. So I'm going to give her a choice of whether she wants to be continued on probation and go to safety, or whether she wants to go to prison.
What is that, CFP?
It's an inpatient treatment facility at the prison.
Oh, at the, they provide housing, because me,
Yes, they
you know,
do.
what, like I said, the organizations that we do, we just basically feel, you know, they need help regardless of what.
No, they're gonna give her help.
Regardless of what the case is, you know, every individual needs help.
No, they're going to give her help if she wants it. So let me have you step back, and I'm going to ask her what she wants.
Your Honor, would that, so we're saying that there's no option for her to at least be interviewed by a felony drug court?
Felony drug court is probably not going to accept her. I'd say 98% because of these charges and the underlying facts that are in these stipulations. So you have a choice. If you want, and these are your only two choices, there are no other choices. So there's no third choice. One, I can continue you. I will continue you and sentence you to safety. Or two, I will revoke you and sentence you to 5 years in the prison.
Okay, but that interferes with my parole that I'm already on. And I'm good on parole. I go to all my classes, I pass all my drug tests, even some of the drug tests that I've come out negative as far as on probation, I've passed on parole. I'm getting help. I go to behavioral therapy, I go to therapy, psychiatrist, I'm on my depression, anxiety pills and everything like that. I'm on a mood stabilizer now that I'm in Bear County, like I
See, these are things that people need to do when they're not
I
in
was
custody.
doing that before custody. I have proof that I was doing that before custody. I went to university, I got into behavioral classes, I got into therapy. When I went to my TAP evaluation, I asked for the intensive outpatient drug course because I told her I felt like I needed the help.
And if I may, Judge, we did verify that with probation. She was only one class away from intensive outpatient, but I think the big thing is that they wrote her glowing reviews. They said she was doing a very good job. That's in the notes. It's also reflected in the court summary.
Any
in terms of
objections
that
to
she
the
was
court
doing-
reviewing the court summary?
No, Your Honor.
All right, in reviewing the court summary, it says that once she just found out she had a warrant, she didn't report anymore.
Yes, Your Honor, I believe, but it's also under the, if I could see it. What I was just specifically referring to was in their justifications. Just that specific language about.
All right, so what I'm telling
despite
everybody.
Their great attendance in the IOP program.
All right, so this is what I'm telling everybody. They 99%. There's a 1%, maybe they'll accept her in the felony drug court, but there's a 99% chance they are not. What I'm telling you is she has a choice. If she would like for me to revoke her, I will sentence her to the 5 years. If not, then, I'll send her to felony drug court, but I'm telling you, felony drug court is not going to accept her. There's a 99% chance they won't accept her. If they don't accept her, she's going to safety. So those are the choices. There are no other choices.
Yeah, I understand this.
Can I have 30 seconds, Judge?
Yes. Counsel?
Yes, Your Honor. If we could, about how long do we think the felony drug court referral would take? Because
They'll probably have it done by next week.
Because there's some questions to ask in terms of whether or not the safety would result in her parole being revoked because it's treated as if, and I would ask the court too, it would be treated as if she's being sent to prison, which would revoke her current parole. That's a question that I would like to know. Because I'm not something at the front of my thoughts. I'm not sure if that's true.
If that's true and it results in that, then we can always bring her back. All right, the court is finding violation of condition number 4 true. Court would deny the motion. Alternate amend conditions to include in custody, a referral to felony drug court. If not accepted, then safety.
Yes, Your Honor.
All right, thank you. Thank you. All right, do you have Ricardo Reyes?
Yes, ma'am.
All right, the court is calling 2025 CR 005931 and 2025 CR 005927, State versus Ricardo Reyes. Can I have parties announced?
Rick Fainer for the state of Texas.
James Tochi for Mr. Reyes.
All right, would you unmute, please, Mr. Reyes?
Yes, Your Honor.
Are you Ricardo Reyes?
Yes, Your Honor.
All right, defense, you filed motions to modify bond conditions. What are you asking for?
Judge, I think we made two different requests. One is for removal. Admittedly, he's only been out of jail for about 3 weeks. We did come into court on Monday, I believe, and we have an application pending before the court, sentencing not due till October. There are special conditions that include no contact with the complaining witness, which Mr. Reyes understands. So it was not recommended, which is the main reason I'm asking. So assuming the court goes along with whether the regular probation or deferred request, it is my belief that the pretrial condition will then fall off. I'm just asking the court to consider doing it in advance since it was not recommended. And the alternative, he does want to get out and work and he has opportunities. He just can't do it because he doesn't have a partial. So whichever the
Any
court.
objection for partial for employment?
Partial, no, but we would object to complete removal. We would ask that his term be limited to just 8 to 5 so he can go out and find work, and afterwards he needs to be back up.
And fees waived as well, Judge. He has,
No objection to that.
he's not been working.
Okay.
Emphasis on as well, no contact with the victim. She is very much not wanting anything.
All right, then the court will grant, if y'all will fill that out, the court will grant the motion for partial GPS waive fees. You will be allowed to be employed Monday through
Friday, 8 to 5.
Monday through Friday, 8 to 5 p.m. And you're still not to have any contact with the complainant. Do you understand?
Yes, Your Honor, thank you.
All right, thank you. You're excused. If y'all will fill that out and I will take care of it. All right, you're aware of an affidavit to surrender surety has been filed?
Yes, I think on multiple cases for Ms. Cromwell.
And do you have any objections to that?
Well, she has an objection that she didn't know that she was in violation of her bond and that she.
All right, Ms. Ramos, come down. All right, if y'all could unmute on your end, please. Hi, so Ms. Ramos is here. And I do have the affidavit to surrender surety.
Yes, ma'am.
And so your reason, now their reason that is listed in here, one is that she's been arrested. So I don't know which case she's been arrested on.
I don't know.
Or was she?
I was at home Monday and because I knew of the hearing that I had today, Mr. Harkowitz had made me aware of that. And then Monday, there was a knock at my door and there was 2 officers that said there was a warrant for my arrest, so.
And my looking on Odyssey, the best I can figure is that the affidavit of surety was signed with regards to the case on the tampering case, which is still in pre-file status.
Okay. Well, counsel, I can tell you, everyone, please whisper. I can tell you with regards to the drug case, they're probably not going to have labs. State, do you know when you potentially would have labs on Virginia Ramos's case?
Now, there is one case that is indicted already, a possession of less than a gram, which is set, I think, on the 25th or 26th of this month.
Well, if you would like to keep everything for that date, we can keep it for that date. If you would like it brought over sooner, we can bring it over sooner. And then I can address those bond issues.
Okay.
So would you like it recalled for the 18th?
What day is that, Your Honor?
That's a Monday.
Well,
Or do you want her brought back this afternoon and you can discuss it?
I've got 2 cases over in federal court, so I'm not available this afternoon.
All right, so I can have her brought back Monday.
That's fine, Judge, and I can hopefully confer with the state.
All right, so Ms. Ramos, on the possession less than a gram case that's before me now, the one where you're not indicted.
Okay.
They filed an affidavit to surrender surety and they're saying it's because you are in custody.
What does that mean?
They don't want to be on your bond any longer. And so whatever contract you have with them, I'm not in charge of that contract. I just look at the affidavits that have been filed and make a ruling. So in their affidavit of surety surrender, they say that they've tried to contact you through the indemnitor, family, friends,
Okay, this is a situation. The co-signer, which was Gilbert Rios, was the one making the payments on the bond itself. He's the one because he had other payments to do as well. Now, I would check in every week with them and I made all my court appearances. And at one time, was I ever made aware of that that bond was behind? Usually if you're one day behind, they call you and they let you know.
All right, so here's the thing about that. That has to do with your contract with them, and nobody's
Yes.
presented me with the contract. The only thing I go off of is the affidavit. So what ends up happening when bondsmen want to get off your bond, they'll file an affidavit to surrender surety. Now, there's some things that's automatic. You've been arrested on another offense. Usually that's automatic because you're already at the Bexar County Jail. What they filed with me on this case, this nightmare case, is because you're in custody at the Bexar County Jail. So I have to sign it because you're in custody at the Bexar County Jail. What I'm telling your attorney, and I'm telling you, I will have you brought back on the 18th, which is Monday, and we'll see what we can do about it. Who knows? Maybe your attorney will file a motion for a bond and maybe I'll grant a PR bond. It just depends.
Yeah, because I have a job, I have my apartment, you know, to take care of and, you know, and I can't pay anything if I'm locked up, so, you know.
All right. So counsel, you say you're in federal custody? I'm sorry, not federal custody.
Hopefully.
You're at federal court. Let's hope nothing happens.
So I have to stay in custody.
Just one second.
Yeah,
You're in federal-
I have 2 pleas over in federal court this afternoon here,
And what time?
2:30.
All right. Do you want to see? We'll hold her, Deputy Laura, if you can hold her, and we'll see if you can zoom in with us after you've completed that.
Okay.
All right. Thank you. All right. The court is calling 2025 CR 003783 State versus Adam Keith. Can I have parties announced?
Ashley Jones for the state.
Bridget Garza for defense.
And are you Mr. Keith?
Yes, ma'am.
All right. Do you have any objection to your attorney appearing by Zoom?
No.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Keith, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are going to proceed on count 2, paragraph B, waive the other counts in paragraph, and we will also waive the repeat offender enhancement allegation.
We have no objections, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
No.
And I'm so sorry, you said you're proceeding on paragraph B of count 2?
Yes, yes, Your Honor.
All right, did you understand in count 2, paragraph B, you're charged with sexual assault? That is a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Keith, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 2, paragraph B, waiving all other counts in the enhancement. Punishment is to be assessed at 3 years in the prison. There's a $1,500 fine. There's no application. There's an affirmative finding of family violence. Chapter 62 registration, and it's a lifetime registration, and there's to be no contact with the complainant. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense in count 2, paragraph B, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right, and just one other thing, did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
And did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Knowing that, do you still wish to continue with the plea?
Yes, ma'am.
All right, State, do you have any evidence to support the defendant's plea?
State would offer State's Exhibit 1 and all attachments.
Any objections?
We have no objections, Your Honor.
All right, and State, have you spoken with the complainant?
We have, Your Honor, in the past, and we've attempted contact recently.
All right, thank you, State. You may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, now I understand why the offer is as it is. The court will find that there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing, counsel?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we're asking the court to follow the recommendation of the ADA and sentence him to the 3 years TDC and give him credit for time served.
All right. Then the court is finding you guilty as previously stated. The court will sentence you to a $1,500 fine, 3 years in the prison, give you credit for any time served. There's to be no contact with the complainant. There's to be Chapter 62 registration, and there's an affirmative finding of family violence. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You can't be drinking alcohol because obviously you're one of those persons who cannot drink, right?
Yes, ma'am.
If you would like, I can recommend the therapeutic community for you at the prison. They may not place you in it due to the nature of your offense, but it's to help you with sobriety and other issues you may have. I can't order them to place you in the program, but I can let the judgment reflect that I think it would be best if you were in the program. Doesn't increase the length of time that you're in custody. Do you understand?
Yes, ma'am.
Would you like for the court to do that? All right. All right. Good luck to you, sir. You're welcome. All right. Counsel, you may be excused.
Thank you, Judge. See you
You're
later.
welcome. All
Bye-bye.
right. Who is here on Joshua Harris? All right. So where are we on this case?
Judge, if I may, so this defendant, we have 3 other cases in this court where this defendant is not a co-defendant. He would be a necessary and material witness for the state. And so at this time, I don't really believe that it would be proper for this prosecution team to be tendering an offer and handling or overseeing the prosecution of his cases that he has pending.
All right. So what?
So we were recessed today to see if someone from another court was gonna come in and handle his cases in this court.
All right.
I never got any communication from the DA's office on that, so I don't know if it needs to be transferred out or if they need to assign it to some.
Tomas Francisco Cantu. All right, so in this case, Mr. Cantu, today is your plea deadline date.
It was, we need to address that, because
Yes.
we came in, I think it was 2 weeks ago, maybe 3,
Mm-hmm.
for our first setting, and we didn't get a pre-trial setting. We went straight from first setting to a plea deadline,
Mm-hmm.
which, based on my scheduling, I didn't have an opportunity and my secretary to download everything over it thoroughly as much as I should,
Mm-hmm.
and to be able to consult with my client in a definite way. So what we're asking for, Judge, I think we're almost there. If you can, the only way we can an extension.
When is your other case set in this court?
I know I have one in January. I mean.
That is always funny. But Sean, Cornelius always does that Tuesday thing with me. Tuesday, yeah.
Or my other one is that I plead no crime before it's time. Yeah, remember the little old winemaker me?
Yes. All right. So I believe you're set in with us for on your other case. Are you set for August 26th?
So put 26 or September is a nice month. Cool.
Well, I will tell you, some in here always complain that it's too cold in here, but Deputy Laura's like, no.
So I can have a month, 30 days, so that would be
All right,
fantastic.
Norma, set this for the week of September 15th for a plea deadline date.
18th? Oh, that's even better.
Okay, that will be your final plea deadline date. There will be no extensions of plea deadline dates. Do you understand?
Yes, ma'am. Thank you, Your Honor.
All right, let me see. Thank you. All right, it is done. All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you, Your Honor.
You're welcome. All right, where is David Woodard? Ah, there you are, Mr. Woodard. All right, Joshua Craig. Counsel, Mr. Woodard, are there any applications in this case?
No, Your Honor. There's one case we're entering a plea on. He also has a motion to revoke.
All right, we'll start with the plea case. Court is calling 2025 CR 009122, State versus Joshua Robert Christian Craig. How do you?
It's Jerry McGee, is my name. They had it, on the paper.
All right, so we're gonna take care of that. All right, so the court is calling 2025 CR 009122, State versus Joshua Robert Christian Craig, AKA Jerry McGee. Could I have parties announced?
Megan Galloway for the state.
David Andre Wood for Mr. McGee.
And are you Mr. McGee? All right, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Judge, is this the cause number ending in?
22. It's the fraudulent use of possession of identifying information.
Judge, I believe they're proceeding on a lesser included
Yes.
offense that makes it a state jail felony.
That's correct, Your Honor.
All right. And counsel, have you received all discovery?
I have, Judge.
And did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. McGee, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of fraudulent use or possession of identifying information Less than 5?
Yes, ma'am.
All right, that's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Judge.
Mr. McGee, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense of fraudulent use or possession of identifying items less than 5 items as a state jail felony. Punishment is to be assessed at 1 year in the state jail facility. There are no applications. This is run concurrent with 2025 CR 000220 and 2025 CC 008696. The state will take in consideration 2025 CR 009123 and 2025 CR 009140. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offers states 1 in attachments.
Any
No
objections?
objections, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court is going to accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Just ask the court to follow the recommendation.
State, is there any restitution or no?
I don't believe so, Your Honor.
All right, the court will sentence you to 1 year in the state jail facility, give you credit for any time served. This will run concurrent with 2025 CR 000220, 2025 CC 008696. Take in consideration 2025 CR 009123, 2025 CR 009140, and there should be no contact with Home Depot. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes.
And did you sign it?
Yes, ma'am.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. We're proceeding with 2025 CR 000220. State versus Jerry Kyler McGee. Could I have parties announced, please?
Megan Galloway for the state.
David Andre Woodard for Mr. McGee.
And you're Mr. McGee?
Yes, ma'am.
All All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
I'm sorry, not sign it, but did you review it?
Yes.
All right, are you the same Jerry Kyler McGee who was placed on community supervision in 2025 CR 000220 for the offense of possession of a controlled substance penalty group 1, 4 to 200 grams on February 6, 2025 for a term of 8 years? Is that you?
Yes.
All right, state, you may proceed.
Violation of condition number 4 in Bexar County, Texas, the defendant Jerry Kyler McGee did then and there fail to report to the supervision officer as directed for the months of March and April 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
We waive and abandon the remainders, Your Honor.
Any objections to the waivers?
No, Your Honor.
All right, did you understand by pleading true to violation of condition number 4, court could find it true, grant the motion, find you guilty, and sentence you up to 8 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor, it is to revoke the defendant's community supervision and sentence him to 5 years in the prison.
Is that correct, counsel?
It is, Judge.
Are you asking the court to follow that agreement? Sir,
Yes.
are you waiving your right to appeal?
Yes.
All right, the court will follow the agreement, sentence you to 5 years in the prison. Give you credit for any time served. This is to run concurrent with 2025 CR 009122. There's to be no contact with the following persons. Savannah Lee, Devin Sanchez Martinez, and there's to be no residing with minors. And no unsupervised contact with minors. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, you're gonna have to, working out the record, you're gonna have to do better in your life. How old are you?
About to be 34.
You're gonna wake up if you continue on this path, and half of your life is going to be gone because you're gonna spend a majority of it in and out of someone's prison. Do you understand?
Yes, ma'am.
So do your best to do right.
Thank you.
All right, good luck to you.
Thanks. Bye.
Yes, that's yours. Who is here on Tricia Harrison? Yes.
Or maybe I had it wrong, I'm sorry.
Tricia, I have Tricia.
I had a middle name, I'm sorry.
No problem. Are you all proceeding on the motion to revoke?
We are, yeah.
Could I have a file stamp for a motion to revoke, please? Thank you. There you are. Court is calling 2024 CR 0452, State versus Tricia Harrison. Can I have the parties announced?
Megan Galloway for the state.
Brandon Lopez from Miss Harrison.
And are you Miss Harrison?
Yes, ma'am.
All right, Ms. Harrison, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Tricia Harrison who was placed on community supervision in 2024 CR 0452 for the offense of possession of a controlled substance penalty group 1 less than 1 gram on July 23rd, 2024 for a term of 4 years? Is that you?
Yes, ma'am.
State?
Violation of condition number 4 in Bexar County, Texas, the defendant Tricia Harrison did then and there fail to report to the supervision officer as directed for the months of November and December 2024 in violation of condition number 4.
How do you plead to that? True or not true?
We waive and abandon the remainders, Your Honor.
Any objection?
No, Your Honor.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility and up to $1,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor, it is to revoke the defendant's community supervision and sentence her to 8 months in the state jail facility.
That's our understanding, Your Honor.
All right, so why should I sentence her to 8 months as opposed to the 2 years?
Well, Your Honor, I do know that Ms. Harrison was heavily involved in Esperanza Court, which is a very intense program. I believe the state and herself gave it the best shot they had. I know there were some complications with the pregnancy, which led to her cutting off of her monitor. She understands that that was an inappropriate, set of actions. She's here before the court, having made those efforts for several, I guess, almost 2 years, right? Asking the court to give her the opportunity to move on by serving more time if she's not judgment satisfied yet, and just moving on, Your Honor.
All right, I'm not inclined to give her 8 months. I'm inclined to give her a year.
Would you give me a moment to give my client about?
Sure.
Your Honor, we're ready.
All right, yes.
She'll take the 12 months, Your Honor.
All right, are you waiving your right to appeal? All right, the court will sentence you to 1 year in the state jail facility, give you credit for any time served. The court will request the therapeutic community. There's $1,000 fine, time and money will run concurrent. There's to be no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? All right, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, so my understanding, you were in Esperanza Court. I believe Esperanza Court reached out to probation to see what could be done. Here's the thing, nobody can help you if you don't want to get help. And sometimes when we're moving through life, guess what? The friends we had before, we have to cut them loose because we have to get ourselves together and work on being with our children. You understand?
Mhm.
All right, good luck to you. You're welcome. All right, who's here on Dinesha Walton?
I am, ma'am.
Can I have a file stamp for a plea bargain agreement, please? Adjourn, can I get a file stamp for a plea? No problem. Thank you. Court is calling 2024 CR 009527, State versus Dinesha Walton. Could I have parties announced?
Hunter Morris for the state.
Michael Belleville for Miss Walton.
And are you Miss Walton? You need to unmute.
Yes.
All right, Miss Walton, you have a right to appear in person.
It's unmuted. Can you hear me?
Yes. Are you able to hear us?
Yes, I can.
All right, Miss Walton, you have a right to appear in person in court, but I am in receipt of a consent to plea by video conference. Did you review that document with your attorney? Did you understand it and electronically sign it?
Yes.
Court will find that defendant has knowingly and voluntarily consented to plea by video conference. State, do you have any objection to the plea taking place by conference?
None, Judge.
Right. Did you review the application for deferred adjudication with your attorney? Did you understand it and did you electronically sign it?
Yeah.
All right, so you're gonna have to speak up. Nobody can hear you.
I think it's just what I'm on, but yes, yes. You can hear me?
Yes. Did you review the true bill of indictment? You're saying yes?
Yes, I did.
All right, did you review that with your attorney?
Yes,
Did you understand it?
yes, I did.
Counsel, do you waive the reading of the indictment?
Yes, we do.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes,
Did you understand you're charged with intentionally or knowingly committing bodily injury against a child, elderly, or disabled person at a state facility?
yes,
That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
yes,
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
yes,
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine.
yes,
Counsel, your client been able to provide you with any defenses?
Yes,
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes,
Ms. Walton, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
no,
Anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yes,
Are you a U.S. citizen?
yes,
Court will find that defendant has no voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes,
According to the plea, punishment is to be assessed at $1,500 fine. State recommends deferred adjudication. There's to be no contact with the complainant, the anger management course, and you're prohibited from practicing as a nurse in the state of Texas. Did you understand that to be the plea?
yes,
Defense, is that the plea?
yes, it is.
State, is that the plea?
It is, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
yes,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes,
Counsel, have there been any such motions?
No, there are not.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years and there be 120 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
yes,
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
guilty,
State, any evidence?
The state tender states wanted attachments, Judge.
No objections.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Yes, ma'am.
All right, anything you wish to say on behalf of your client?
My client is in Chicago. She understands, she should not have slapped this individual. She does accept responsibility for it. She would just like to move on and be able to work and complete her probation without any problems.
All right, so how much training does she have in the field? Is she a licensed nurse, or is she a person that somebody hires and says, hey, we need somebody to come in as a caregiver?
She will have to answer that one.
All right, are you a licensed nurse?
No, I'm working towards getting my CNA.
All right, so this is a situation where somebody just hired you to come in and work in the facility.
I'm a caregiver.
All right, so what's your level of education to be a caregiver?
I finished high school.
All right. See, this is what I mean. Everybody's just letting everybody be a caregiver. And the problem is that being a caregiver for somebody, I think that's sort of like a calling. You have to have said, you know what, I'm going into that field, because you're dealing with people who have dementia, Alzheimer's, people who can't take care of themselves, people who need somebody to bathe them. The patient gets upset because they're not doing what they're allowed to do anymore. They can't communicate because they have dementia and Alzheimer's. Then everybody and their mothers just hiring random people, paying them minimum wage or less than. And then we end up here with somebody slapping somebody who has dementias and Alzheimer's. So I know y'all say she's prohibited from practicing as a nurse in the state of Texas. Okay, but she's not a nurse. She's not licensed to be a nurse. This is just somebody that somebody just hired off the street and said, hey, you have a high school diploma. You want to receive minimum wage to take care of people that nobody else maybe wants to take care of. And this is where we end up. And what was the name of this facility? Let me see. Chapters Living of San Antonio. All right, this is what the court is going to do. Does anybody want to speak to length of probation? The state is asking for 3 years. All right, court is going to sentence you to 5 years deferred adjudication. There's a $1,500 fine. There is to be proof of employment within 30 days. There's to be no employment as a home health care provider, no employment with working with minors, no employment with working with people who are disabled. There's to be no practicing as a nurse in Texas or anywhere else. So I'm just going to say no practicing as a nurse. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. 120 hours of community service restitution. The $1,500 fine will be probated. There's to be anger management. I'm ordering anger management because you all agreed to it, but it just appears that you were a person who should never have been working with someone in any type of facility, or young children or people who have mental health issues. That's just not a field for you. Probation, is there anything else? Yes, what county are you in? I'm sorry, where?
Cook.
All right, she's allowed to transfer to Cook County in Illinois. Is it Illinois?
Yeah.
And Judge, if I may.
Yes.
Is this court inclined to include a no contact for Ms. Maria La Rochelle?
Yes, and there's to be no contact with Maria La Rochelle, and there's to be no residing with the elderly. And for the court, I'm putting elderly at anyone over the age of 60. Probation, anything else? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Good luck to you. Don't take any more of these positions that requires you to have patience and that requires you to be with someone who has dementia, Alzheimer's, they're elderly, they need somebody to be kind and patient with them. You should work in those positions. Do you understand?
Yes.
And I do fault the company that hired you as well. All right. I'm going to send you to the breakout room. Probation will go in the breakout room with you and go over conditions. And I will place you in breakout room number 2. Mr. Bellevue, do you have anyone else with us?
I do not, ma'am.
All right. Thank you.
Thank you.
Thank you for your patience.
Yes, ma'am. Thank you, Judge.
You're welcome. Angela Lee Redwine. Court is calling 2020-24 CR 007292 State versus Angela Lee Redwine. Can I have parties announced?
Megan Galloway for the state.
Robert Ramirez from Miss Redwine, Your Honor.
And are you Miss Redwine?
Yes.
Did you review the document entitled Motion to Revoke Community Supervision and First Amendment Motion to Revoke Community Supervision? With your attorney, did you understand it? Thank you.
Yes, Your Honor.
Thank you, Miss Abrams. No. Yes. All right, we can go off the record. So what is the plan for Miss Redwine?
Your Honor, we were going to ask the court to alter and amend her conditions to add the moral recognition therapy course.
And then what's going to happen to these other cases?
I've not received all the evidence from the arresting agency, and so at this point, I cannot make a representation to the court about that because our office has not received the cases.
Okay. Who is the alleged complainant?
If I can.
I can answer that, yeah.
Yes.
Joseph Friedman.
Joseph who?
Friedman.
You say Friedman?
Yes, Your Honor. FRIEDMAN. And he asked me to assist him in preparing an affidavit, not prosecution. That's been filed with the court, Your Honor. It speaks to all 3 of these allegations.
All right.
Judge, and if you could just give me a minute, because there were some other individuals that were involved. A judge, so one more person would be a no contact order with an Andrew Garcia.
All right, this is what the court is going to do. The court has signed the motion to withdraw. The court is going to alter and amend conditions to include the MRT. There should be no contact with Joseph Friedman, Andrew Garcia, and no residing with the elderly.
Judge, and then there's one more person. It's a Jim Michael Ferguson.
And no contact with Jim Michael Ferguson. And so for the court, the elderly will be anyone over the age of 55. Thank you. I consider myself elderly.
Judge, the last name.
It's Jim Michael Ferguson. And the other one is Andrew Garcia and Joseph Friedman, FREIDMAN. Thank you.
Thank you, Your Honor.
You're welcome. Barbarians. All right, David Cortez.
Yes.
Come down. Your attorney's by Zoom at the beach. Yeah.
Yeah,
At least-
drove.
He's not driving. All right, so what is happening with this case, Mr. Behrens?
Okay, Judge, a long time ago, we had
got on to represent Mr. Cortez. That was in, I think, spring of 2019. In October of 2019, you appointed Armando Martinez to do an immigration evaluation under Padilla. According to Mr. Cortez Jimenez, that never really happened. He spoke with Mr. Martinez briefly, but there was never anything after that. So that still needs to get done. And I'm concerned about it because this is an evading detention with a vehicle, and which other attorneys I know tell me can be considered aggravated felony under the INS code. So
Yeah, so I think that person was appointed through the MAC, but we're going to see if the MAC can't do it, we can have someone else do it.
yeah, FYI, I did send it in for another referral today while we were in court online with the MAC, and waiting to hear back. But if you can get something done sooner, I'm sure Mr. Cortez Jimenez would appreciate that.
All right, do you want someone appointed, a private person appointed?
Well, I want whatever works quickest.
All right, Ms. Ferguson?
Yes, ma'am.
If you'll call Mr. Behrens and see if he has any objection to the private person who can take care of the immigration issue. All right, so Norma's going to call you with some names and then you just let us know.
Sure.
And then, sir, we're going to call you back. Norma, we're going to put it at a 30-day setting, but if you have the information before then, just let us know.
Okay. Yeah, because they're offering them deferred, but again, I just don't want to take any chances.
All right, Ms. Ferguson, can I have a 30-day reset? All right, so we're going to bring you back on September 18th, but we'll make sure that an immigration attorney is appointed to represent you.
And
For your
hopefully get
immigration as it relates to the findings on this specific case. They're not your immigration attorneys outside of this criminal case. Do you understand?
Si me puedes decir en español.
All right, if you can let him know that the immigration attorney who's appointed to represent him is only representing him as it relates to any outcomes this case will have on his immigration status.
Yeah, and they can call me and I'll explain what's the situation.
All right, thank you, Mr. Behrens. All right, Anthony Belk.
Yes, ma'am.
All right, are you all ready to proceed?
Yes, ma'am.
All right, and Mr. Behrens, they took your client back. Ms. Ferguson will call you with names. All right, the court is calling 2025 CR 008765 State versus Anthony Jamal Belk. Could I have parties announced?
Valley for the state.
Attorney Wilson for the defense.
And are you Mr. Belk?
Yes, ma'am.
Are there any applications in this case?
No, Your Honor.
No, Your Honor.
Mr. Belk, did you review the defendant's consent to appear by video conference with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Do you understand you have a right to appear in person in court?
Yes, ma'am.
All right. And are you consenting to appearing by video?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by Zoom. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, the state moves to proceed on the lesser included offense of possession of a controlled substance, PG1 less than 1 gram.
Any objection?
No objection, Your Honor.
All right, Mr. Belk, did you review court admonishments with your attorney? Did you understand it? Oh,
Yes, Your Honor.
too loud or something. Did you agree? Did you review that with your attorney? Did you understand it and electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand?
We did sign it manually.
Ah, okay, thank you. Did you understand the state is proceeding on the less included offense of possession of a controlled substance penalty group 1 less than 1 gram? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he is currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Attorney Simmons, have you received all discovery and you reviewed it with your client?
Yes, ma'am.
And Mr. Belk, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the state is in compliance with discovery. The court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 97 days in the Bexar County Jail under 1244. There is to be $60 restitution to the Bexar County Laboratory for testing. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, ma'am.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there been any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers states one in attachments.
No objection.
All right, state, you may be excused. Did you review the stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
Your Honor, we just pray that the court follow the plea agreement.
All right, the court will sentence you to 97 days in the Bexar County Jail under 1244. Give you credit for any time served. There is a $60 restitution to the Bexar County Laboratory for drug testing. There's to be no contact with Adam King or Jason Wayne King. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right. And to the clerks, does this show a judgment satisfied or not?
It was the intention for a judgment satisfied.
I'm sorry, what?
It was the intention of a judgment satisfied on the paperwork.
All right. So what I can tell you, Mr. Belk, is I will give you credit for whatever time you have in the Bexar County Jail. If for some reason there's an issue with the amount of time you receive, you can let your attorney know and we will make sure it is completed properly. However, the most amount of time that you can serve at the Bexar County Jail is 97 days. Anytime that you've been in custody in the county that you're currently in Burnett, that will count towards your jail time here in Bear County. If you're holding out for Bear County's giving me 2 days for every day I serve or 3 days for every day I serve, I'm not in charge of that. That's something the jail does. I have no control over that. What I can tell you is your agreement is for 97 days in the Bear County Jail. You will not do more and you should not do more than 97 calendar days. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank
Stay
you,
out of
ma'am.
trouble.
Yes, ma'am. Thank you.
All right, who's here on Ezra Espinoza? Good morning, or afternoon, I should say.
How you doing?
All right, how are you doing?
Doing all right.
There are applications in this case?
Yes, there is, Your Honor.
Is there a restitution amount?
There is. There is an agreed restitution.
All right, and what's the agreed restitution amount?
$5,000, Your Honor.
And are you gonna be able to pay the 5,000?
No, but I'm gonna have to look for a job pretty soon.
How old are you?
19.
All right, is there any chance that he's gonna be able to pay
I
this?
looked into it, Judge,
Mhm.
and it's, there is also, after you read it, there is a weapon involved and also drugs involved, and also just because of the nature of the actual crime, it seems that it might have been a repetitive behavior.
All
Not
right.
that he has anything in his past, but that's the reason I've decided to go with this.
Oh, no. He's gonna have to pay restitution. I'm just figuring out when is he gonna pay it?
Sure, I think he can. I don't think if today he has to pay it. I think that's what he's answering. No, he can't do it today, but I think given the course of deferred, I think he can.
All right, so when will you be able to pay at least $1,200?
I can see if I can get some money together pretty soon, probably next week.
All right, are you staying with your parents or
Just my mom.
your mom? And your mom's employed?
Yes, ma'am.
What does she do?
She works for the Texas Lottery Commission.
Okay.
Yeah. So
Why am I not winning anything? I try.
I think it's designed that way, Your Honor.
Well, no, honestly, I will tell you, when I first came to Texas in 1994 for law school, I actually did a scratch off, super broke. And I'm like, thank you, God, I won $500. And guess what ends up happening? Do you know you couldn't go to the gas station to get $500? And I'm like, I don't have a vehicle. I can't get to Austin, take a bus to Austin, then try to find it. The only people who would pay you money for up to $500 was Albertsons. And then I had to find somebody. Does anybody know where Albertson is? And it was like law students. They're like, oh, we'll drive you to Albertson. Ooh, that $500. I was the wealthiest person for about, I don't know, a month. All right, because lunch was expensive on campus. But the guy who worked there was always nice to me. He would let me pay him installments. So all I would eat every day was one meal. And that would be a Philly cheesesteak sandwich.
Those were good. Okay.
Oh, they were so good.
Yeah, I remember.
Yeah. All right, court is calling 2025 CR 007442 State versus Ezra Espinoza. Can I have parties announced?
Jason Gary here for the state, Your Honor.
Patrick Laws for the defense.
And are you Ezra Espinoza?
yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
All right, you're charged with theft of property, 2,500 to 30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, court does not have to follow your plea. If I don't follow your plea and give you more than you all have agreed upon, you can withdraw your plea, start over, or go to trial, and it cannot be used against you. Do you understand?
Yes, Your Honor.
You have a right to a jury trial. Do you understand what a jury trial is?
Yes, Your Honor.
By entering this plea, you're giving up the right to a jury trial. You're giving up the right to remain silent, and you're giving up the right to have your attorney question any witnesses. Do you understand?
Yes, Your Honor.
Is that what you want to do?
Yes.
Did you understand that the court grants your application for deferred adjudication if for any reason a motion to revoke is filed against you? And if you are revoked, I could sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Right, do you understand that state jail felony time is day for day? There's no 2 for 1 or 3 for 1. Do you understand that? Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. Espinoza, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than what your plea bargain is?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
All right, according to the plea, there's a $2,000 fine. State is recommending you receive deferred adjudication. This is going to run concurrent with 2024 CC 736745. There's to be restitution, and it's agreed upon, to Clara Valle of $5,000. Did you understand?
Yes, Your Honor.
Is that the plea defense?
It is, Your Honor.
State?
It is, Your Honor.
Did you review that waiver of appeal paragraph with your attorney? Did you understand it?
Yes, Your Honor.
Did you sign it in both places?
Yes, Your Honor.
By signing that, you're giving up your right to appeal. That means that you can't complain about anything unless your attorney has filed some sort of pretrial motions, and I've made a ruling of those, on those. Do you understand?
Yes, Your Honor.
Has there been any such motions?
No, Your Honor.
So you will not have a right to appeal. Do you understand?
I understand.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years, that there be a TAP evaluation, 160 hours of community service restitution. What that means is you go somewhere and you work for free. And if it's 160 hours, that means you have to work 160 hours. Do you understand?
I understand, Your Honor.
And there's to be no contact with Clara Valle. Did you understand?
Yes, Your Honor.
Now, what the state is asking for there, that's not a part of your plea bargain agreement. I don't have to follow it. Do you understand?
I understand.
Right, then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State Exhibit number 1 with all of its attachments.
We have no objection, Your Honor.
All right, did you review the stipulations with your attorney?
Yes, Your Honor.
All right, the stipulations have the police reports in it. It's supposed to have all of the documentation that the state needs in order to prove to me beyond a reasonable doubt that you committed this offense. Do you understand?
I understand, Your Honor.
So again, state is not going to call any witnesses. Their witnesses are in the form of the documents in this paperwork. Do you understand?
Yes, Your Honor.
You're giving up the right to remain silent. So what does that mean? I can ask you questions. The state can ask you questions. Do you understand?
Yes, Your Honor.
And there's not going to be anybody called for your attorney to question unless your attorney decides to call someone. Do you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and submitted to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. All right. We can go off the record. This is what I want to know. The restitution is $5,000. That person wants their $5,000. I understand sometimes people will come before me and they're like, I don't have $5,000. And I'm like, you should have thought about that before you did this. So you're not employed. Your mom is trying to work. And how many siblings do you have?
5, but they don't live with me.
They don't live at home. So it's only you and your mom? Does your mom have a mortgage?
I believe so.
All right. And she has a car note?
Yes.
And she has insurance to pay for that? You're not working, so she pays for you to live, right? She has to pay for you to have food, pay for your clothing and everything. Am I right?
You're right.
All right. Did you graduate from high school?
No, I did not.
Why not?
I don't know, I never went. I went, but I just never stayed. They ended up kicking me out.
All right. So here's my question for you. Do you love your mom?
Yes, I do.
Do you care about her? It doesn't seem that you do. And let me just tell you why.
Why?
She's working hard and she's working hard and she's supporting you, putting a roof over your head, paying for your clothes. And I'm sure all she has, her expectations of you, is probably the same expectations my mom had of me and my siblings was go to school. And you know, my mom would always say, you know what, after you get out of school, you can run around and play a little bit because for her school, she's like, that's sort of like a job because you're there at the beginning of the day and then all through days, and then you're dealing with different personalities. So your mom is doing all of that for you, and you're not doing anything except this, getting in trouble. And I already know what's going to end up happening with this $5,000. His mom is going to probably end up having to pay for it.
Well, I will say he didn't put it on the application, but he is doing part-time work. It's not really steady work, but he is working.
All right. So, and how far did you go in school?
To ninth grade.
All right. He can't do much with that. And I can tell you right now, I'm not allowing you to work as a home health care provider, and they're just out here hiring anybody. Not all places, but some of them. So you're going to have to get employment. You need to pay this, not your mom.
I will.
So I'm going to reset this. So when can you come in to this court with $1,000?
Probably next week.
Okay, here's the thing. Don't do that next week because when you come in with $1,000, it has to be from legitimate sources. It can't be you doing whatever you do to make extra money. It has to be legal work, and it can't be you calling around all your relatives or friends asking them to borrow money, because when you ask them to borrow money, when the payment becomes due for them on that, it's going to cause you stress and it's going to be hectic and you're going to start ducking and dodging them. So do you want to talk to your attorney about when you can actually come to this court with $1,000?
I mean, I have a little bit of money saved, so would that be good, or?
How much money do you have saved?
Like 800.
All right. So when can you get the other two?
Do not know right now.
Right. See how easy that is? You come to me saying you can get $1,000 and you're dependent in your mind on somebody else to give you the two. So when do you think, because you're working part-time, I know FICA comes to you when you work part-time, as FICA comes to everybody. You're like, who is this FICA person? But they're always there with their hands up before you even see anything. So when do you think you can have $1,000?
I don't know.
You want to?
Do you think you can have it by, let's say, 4 weeks from now?
Yeah. 4 weeks from now, I'll get a job probably.
You think so? I mean, they're hiring at McDonald's and everywhere.
Yeah, yeah.
All right. So don't burn the chicken and change the oil. All right. Miss Ferguson, can I have a 30-day reset? September 18th. All right. So September 18th. And if for some reason you can't come in with $1,000, you need to come in with at least 800 because that person wants their money. You understand?
Sorry.
And I don't know how they do different places now, but I remember when I was working, Vashon, the day I worked at Walmart, they always put my mother and my grandmother would always call it, you have to have a check in the hole before you even see your first check. So I don't know if they still do that now. I know with young people, somebody was telling me now, they give you a credit card and put your check, put your pay on it.
Some places, yeah.
And then if you lose that card, then where are you? So you're going to have to start making some changes. And if you truly love your mom, then your behavior should show that. You understand? All right. So we're going to bring you back on September 18th. You need to come with this money because that lady wants that money and can't be cash. State, you all don't take cash upstairs anymore with the cashiers.
It's either a money order or a cashier's check.
Cashier's.
All right. So you need a money order or a cashier's check. And last time I checked, depending on the bank where you bank at, they're going to charge you a fee for that, or either they're going to charge you a fee for the money order wherever you go. All right.
It's 89 cents of each of them.
Okay. There you go. HEB.
Thank you.
All right. Thank you for dressing appropriately for court.
Thank you.
Court is calling 2025 CR 08286, State versus Virginia and Ramos. Could I have parties announce?
Jason Garahan for the state, Your Honor.
Stephen Harkowitz for Virginia Ramos.
And are you Virginia Ramos?
Yes, I am.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Ramos, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, I do.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, I did.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
All right, you're charged with possession of a controlled substance penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yeah.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Ramos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
I am.
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's a $500 fine. State will recommend deferred adjudication. They're taking in consideration NIMAC number 742027 and 742028. There's to be restitution to SAPD for drug testing. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation and 100 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Yes, Your Honor. State Exhibit number 1 with all of its attachments.
No objections, Your Honor.
And state, do you have the dismissals for me to sign? Thank you. And state, you may be excused.
Thank you.
Thank you. All right, did you review the stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Correct.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, I'd like to, Your Honor.
Anything you wish to say on behalf of your client?
I would just ask the court to grant the deferred adjudication as recommended by the state and, Ms. Ramos understands, her responsibility to this court and what can happen if she doesn't follow through.
All right, are you employed?
I am.
What do you do?
I do sales. I
Selling?
do metal art, like for your yard.
Oh, wow.
It's called Little Red Bird.
Oh, Little Red Bird. I'm gonna
It's
have to look
located
that
on
up.
Culebra and Colorado.
Yeah, because those metal swans, the prices on that are outrageous.
Yeah.
Like $300 for one swan. And everybody knows there needs to be a pair, right?
Yeah.
All right, so it appears that you have a drug problem. So when is the first time that you started using?
Oh, years ago. But it's like just randomly, but
I mean, because this offense date is not from years ago.
no, I understand that. I understand.
So here's the thing, when people are placed on probation here, I try to give them the help they need because I want them to be successful. I take no pleasure in revoking people and sending them to prison.
Miss Judge Boyd, I do not plan on coming back.
Mhm.
I went in jail for 4 days. And that was sufficient enough for me. I plan on doing what I'm supposed to be doing
All right.
and not doing, which is not doing anything.
All right. So this is what the court is going to do. There's a $500 fine that will be probated, 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, taking consideration NIMAC numbers 742027, 742028. The TAP evaluation can be done out of custody. Follow recommendations except if they suggest inpatient treatment, we'll start with intensive outpatient treatment. There's to be restitution to SAPD for testing. Proof of employment within 30 days. No employment as a home health care provider or with minors. And do you live by yourself?
I do.
All right. There's to be no residing with minors. And no unsupervised contact with minors. Do you have any grandchildren or children?
I have a son that's 23, or he'll be 23, but doesn't live with me.
All right, and no grandchildren yet?
No grandchildren yet.
All right.
Not that I know of.
So there's 100 hours of community service restitution. I'm going to require sober support meetings. So for every sober support meeting that you complete, an hour will be deducted from your community service restitution. Otherwise, you're going to be picking up trash somewhere. That's what they have available. You understand?
Yes.
Probation, anything else? All right, field visits, 1 time per month for 4 months. Is there anything else you need from the court to be successful?
Will I get a list of the places where I can do like the sober?
Oh, yes. If you Google them, if you don't have a computer or anything, probation will let you know. But they actually have them all over town and you can find a sober support meeting at any time of the day or night. They're open 24/7.
Okay. And the UAs are done.
Probation will let you know.
Okay.
Yes. Okay. All right. Is there anything else you need?
No.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
We can go off the record. Good luck to you. If there's anything you need, don't hesitate to let your probation officer know about it. If you feel they're not addressing the issue, you can always come back here. If you feel as though you're going to pick up the phone, call your probation officer, and you know what's going to end up happening? They're going to send it to me that you've called them, that you are about to use, and they're going to see what help they can give you to help you with that.
Okay.
So don't do this thing where you don't show up and you just disappear, because we can't help you if you disappear.
Right.
All right, and we'll recall the warrant if there's a warrant for her so that she can be released. You'll probably be released at 1 a.m. Why that happens, I don't know.
So, but I will be released though, right?
You will be released. I'm going to put it in the system today.
Okay. Thank you so much.
You're welcome. Good luck to you. Thank you,
Thank you,
Ms.
Judge.
Hopkins.
Okay.
All right, so everyone, tomorrow I have felony mental health court. But we don't have anything on the docket, do we? All right, so we don't have anything on the docket, so I will see you all on Monday.